Hi everyone, Dave Sugden of Evidence at Trial. We're talking about the People versus Donald Trump case now pending in New York, and specifically we're talking about Donald Trump's testimony. In our last video, we discussed the importance of leading questions, especially with a witness like our former president. And yet, what we saw were painfully broad and open-ended questions that essentially gave Mr. Trump a platform to deliver long narratives that conveyed his theme of the case. And as we focus on Mr. Trump's testimony to examine what was done versus what could have been done, we do need to look at the role of the judge in this case, the Honorable Arthur F. Engoron. Now, the role of the judge is important but limited during trial. In fact, we see in New York's Guide to Evidence that the judge is responsible to oversee the mode and order of presenting evidence and examining witnesses, and also, provided the court does not assume the function or appearance of an advocate for a party, the court may on its own rule that a question is improper or that a response was not proper. And that's basically it. Indeed, Chief Justice John Roberts once explained how he saw the role of a judge, and it's worth looking at what he said and compare it to the role that Judge Engoron has been playing in this case.
Judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire.
According to the Wall Street Journal, Judge Engoron has been able to maintain an inordinately active social life during this trial, writing dozens of newsletters for his high school alumni, lifting weights, and pitching a screenplay while overseeing a case that he claims is not political at all. Whether or not the judge considers this a political case, he has to be aware of the attention it's getting, and his decision to insert himself repeatedly during the questioning of Mr. Trump, it was pretty stunning. Early on in the testimony, we see the judge step in and admonish the former president, telling him that he's being very patient and he would like to move things along a little faster. He tells Mr. Trump that he should just answer the question, give no speeches, and that the examining attorney is going to ask questions, Mr. Trump is going to answer them, and he, the judge, is going to make sure that happens. Now, this is not terribly unusual for a judge to step in early and remind a witness to provide responsive answers. What was unusual, however, was that throughout the testimony, we see Judge Engoron not only insert himself by lodging and sustaining his own objections, but making snarky and argumentative comments to the former president. For example, when Donald Trump offered testimony about the disclaimer clause, Judge Engoron, without any objection, without any motion to strike, told Mr. Trump, no, we are not going to hear about the disclaimer clause. If you want to know about the disclaimer clause, read my opinion again, or for the first time perhaps. Now, I have no doubt that having a witness like Donald Trump on the witness stand will test any judge's patience, but being passive-aggressive or sarcastic with a witness suggests the opposite of being unbiased and neutral. And we saw this throughout the examination. Even without the examining attorney seeking any intervention from the judge or moving to strike an arguably non-responsive answer, we hear the judge offering to help. He tells the examining attorney that he is following his lead, and if you want to let the witness ramble on, be unresponsive, repeat himself, go ahead. Later in the afternoon session, he reiterates his willingness to step in, telling the examining attorney, "This morning I said I am following your lead in terms of how much you want to put up with this stuff." The reality is that these overtures to assist are rare from judges. As practitioners, we cannot count on the judge coming in to help. There were even occasions where, after a question, the judge would turn to Mr. Trump's attorney and ask whether certain parts of Mr. Trump's testimony were necessary. For example, Mr. Trump was asked, "What did you do to meet your responsibility for the preparation and fair presentation of this financial statement in accordance with accounting principles generally accepted in the United States?" Mr. Trump actually asked for clarification, saying, "Me personally," and the examining attorney says, "Let's start with you personally." Mr. Trump does what he does and gave a self-serving response, and without any request from the examining attorney to strike the answer, the judge turns to Mr. Trump's lawyer and asks whether one of Mr. Trump's comments about the judge always ruling against him was necessary. Mr. Trump's attorney emphasized the open-ended nature of the question, and the judge cut him off, saying, "I think it was a yes or no question. Was he responsible?" But it wasn't a yes or no question. It was virtually the opposite of a yes or no question. And yet the judge felt compelled to insert himself and narrow the examination. In most instances during trial, we as lawyers are on our own to rein in the uncooperative witness. This type of behavior where the judge is showing an eagerness to be involved, it's really rare. The truth is that the best way to do so, the best way to keep these witnesses in line, is to ask better questions. Again, we lawyers, we have just one tool to do our job, and that is the tool of asking questions. Good questions is the best antidote to the non-cooperative, non-responsive witness. And practitioners, we should not count on any judge to unilaterally weigh in to help. Folks, I hope this was helpful. If it was, please subscribe, hit the like button, notification button. If you want a topic covered, leave a comment. And if you want to do a really deep dive on these evidentiary concepts and how to apply them during trial, check out our online course page at evidenceattrial.com. Thanks for watching.